And I call the member for Wright.
Thank you, Mr Speaker, and I move that the motion relating to Lieutenants Breaker Morant, Handcock and Witton, in the terms of which it appears on the notice paper. Mr Speaker, Harry Breaker Morant is a name which is synonymous to all Australians, but maybe not for the right reasons. Breaker Morant, the movie produced in 1980, afforded the characters Edward Woodward, Brian Brown and Lou Fitzgerald as they depicted three army personnel. And it spoke of the executions of Lieutenants Harry Breaker Morant and Peter Handcock on the 27th of February 1902, some 116 years ago, and the sentencing of Lieutenant George Witton to life imprisonment. But the issue continues to ignite passionate debate about the guilt or innocence of these men and calls for the acknowledgement and the relief for the descendants. And I wish to acknowledge some of the descendants of Lieutenant Harry Breaker Morant and Peter Handcock and George Witton as they sit in the chamber today, Mr Speaker. Michael Handcock, Leslie, yep, thank you. Merrill Urban and Richard Williams, thank you. Beverly Little and Tony Little. Lynette Pont, all descendants of Harry. And Jennifer Witton Sand, beautiful, descendants of George Witton. Anne and Kathy Morant, descendants of Breaker Harry Morant. And Beach Thomas, descendants of Major James Thomas, their Defence Counsel. I acknowledge and welcome you here today to the Australian Parliament. And to their advocate, James Uncle and his wife Maris, and the historians Shane and Melissa Williams, who are in the chamber to witness this moment. James, thank you so much for the work that you've done in preparing this auspicious motion today. Today I acknowledge that Lieutenants Morant, Handcock and Witton were not tried in accordance with military law of 1902 and suffered great injustice as a result. The convictions were unsafe, unlawful, and the sentences illegal as appeal was denied, and provided an opportunity for the Parliament. This provides an opportunity for the Parliament to discuss this. The war between Britain and the two Dutch South African republics, the Boer War, began in 11th of October 1899, where the Boers declared war on the British and lasted until the 31st of May in the year 1902. During the Boer War, approximately 16,000 Australians served under British command, and about 600 Australians died during the conflict, and it was the first major conflict involving Australians overseas. Harry Morant, Peter Handcock and George Witton, like so many other volunteers from the Australia and Commonwealth countries, joined up to support the Empire. The three men became commissioned officers and joined a volunteer unit called the Bushveld Carbineers. These men shot 12 Boer prisoners while acting under the orders of senior British regular army officers. This fact is not in dispute. The court-martial made significant recommendations for the three accused with respect to shooting the Boer prisoners. The court strongly recommended that due to mitigating circumstances, including their lack of previous military experience, their ignorance of military law and good military service during the war, that mercy should be shown during the trial and their sentences. The courts-martial and Lord Kitchener, military commander-in-chief, confirmed their sentences on the 25th of February 1902. He commuted Witton's sentences to penal servitude and ignored the court's recommendations for mercy for Handcock's and Morant. Following the trial in 1902, Lieutenant Morant and Handcock were executed, and Lieutenant Witton was in prison, but released from prison following the representation from Australia and British parliamentarians. Today I acknowledge that the process used to try these men was flawed and that they were not afforded the rights of the accused person facing serious criminal charges enshrined in military law in the year of 1902. The prosecution had 3 months to prepare cases against the accused before trials that commenced in January 1902. It was in stark contrast to Morant, Handcock and Witton, who were denied the right to consult legal counsel until the 15th of January 1902, leaving 1 day's preparation before trial to seek legal advice on serious allegations and complex issues with their defence counsel. Major James Francis Thomas, of whom they had no previous contact. Their confinement and their limited time to prepare a defence included locating and interviewing witnesses. This prevented or frustrated them from mounting a defence to charges of murder. The circumstances that led to the execution of Morant, Handcock and the sentencing of Witton to penal servitude was characterised by indecent haste as a disregard for the rule of law and the appeals process. And this is what this motion speaks to, Mr Speaker. It speaks to the fact that these officers in the Australian Army serving as volunteers were not afforded their right to an appeals process. They were also prevented from communicating with their relatives, their Australian government, and most importantly the Sovereign King, who could have examined their pleas for clemency. Had they been strayed for a few days, Handcock, Morant and Witton could have discussed their options with legal counsel, have sought advice from the Australian government, as the military standards would have normally provided. Lord Kitchener made himself unavailable for the sentences, were announced and could have not been contacted, denying an opportunity for the accused to seek his reconciliation for these sentences. Lord Kitchener's actions ignored due process and denied an opportunity for an appeal to allow the men to exercise their right to a state or military redress of grievance. The sentences were carried out within 2 days of convictions and the sentences being announced. The accused were denied the opportunity to consider all avenues of review, including appeal action, with this unnecessary haste. The laws of war prior to 1928 permitted reprisal against prisoners. Take no prisoners order was then a lawful order and was constructed by such Morant, Handcock and Witton. This demonstrates that the British military had to take decisive action in fighting a devious guerrilla campaign waged by the Boer. Kitchener's decision to issue such orders was considered lawful, according to the law of 1901, and one that had to be obeyed by the men. At the time of the offences, the law were relying on superior orders was recognised as a legal offence in certain circumstances. Mr Speaker, Sir Isaac Isaacs, Witton's defence counsel, second defence counsel, who eventually served as Governor-General and Chief Justice of the High Court, and a submission on Witton's culpability, obedience to superior officers, limited military experience and disproportionate sentences could also be applied to the cases of both Morant and Handcock. Following a petition signed by over 80,000 Australians and support from the Australian and British parliaments, Witton was released from prison. Several members of the legal community have also supported the expression that we have here today. In mention, David Denton, QC, Robert McClellan, former Attorney-General, Sir Lawrence Street, QC, Supreme Justice of the New South Wales Court, Geoffrey Robinson, QC, Jerry Nash, QC, and Sir Lawrence Street, QC, Chief Justice of the Supreme Court of New South Wales. I acknowledge the descendants of Lieutenant Harry Breaker Morant and Peter Handcock and George Witton. The treatment of these men has caused them much grief and shame. And over the years, their family have had to try to deal with the guilt of the ways of these men were treated. The collective grieving has been in secret, fearful of they would be shamed for the events of all those years ago. I'd like to express my deepest sympathy to all those in the chamber here as descendants and hope that this motion will go some way to easing your pain from 116 years ago. The Australian support for the British during the Boer War was significant for an emerging nation. This motion regarding Handcock, Morant and Witton recognises their service, respecting that duty to obey the orders of the British superiors and be loyal to the Crown. Lieutenants Morant, Handcock were the first and last Australians executed for war crimes on February 27, 1902. The process used to try these men, Mr Speaker, was fundamentally flawed. They were not afforded the rights of an accused person facing serious criminal charges enshrined in military law of 1902. And today I recognise the cruel and unjust consequences and express my deepest sympathy to the descendants and thank their advocate, James Uncle, for his ongoing work in recognition. Today I acknowledge the Morant Handcock descendants, and I note that this appeals process, again, will help bring some closure to what is an oversight, a travesty of military justice, But it is through these few words in this chamber that I hope you find relief and that the history books will reprieve you. Thank you.